Good afternoon, everybody. This is Dalia Anise. I am estate planning attorney with Legacy Life Plan. Before we get started, I just want to make sure, can everybody hear me? If you can hear me, just put a yes in the chat. Just want to make sure we don't have any technical difficulties. Can you guys hear me? Yes? Great. Okay. Also, before we get started, just want to get an idea of where you are so I can use our time to best support you and focus on the certain things that you care about the most. Are you, do you have minor children or adult children? So if you put minor or adult in the chat to give me an idea where you are, what stage in life you are in, that would be great. That would really help me to focus on more specific things that would support you at this time in your life. Okay, all right. Thank you for that. Okay. All right, let's get started. I want to share with you, let me share my presentation, and I will be off camera so that you could just focus on seeing this. Everybody see my presentation? Yes? Perfect. Awesome. Okay, so again, my name is Dalia Anise. I am an estate planning attorney with Legacy Life Plan. I will be your host today. We're going to be discussing wills, trusts, and incapacity. Definitely not the most exciting topic to be thinking about, but how it affects your life is mind-boggling. Today, I'm going to be sharing some of my experiences, some stories. I always say I've heard the good, the bad, and the very sad stories that people go through in life. And unfortunately, there are points of, I want to say, where it's too late to create an estate plan. And I'll share an interesting situation that actually, a call that I just got an hour ago from someone in that situation. Okay, so before I get started, I want to just give you a little bit of background information about me. This is my family. This is my husband. We've been married for 36 years. And my daughter and her husband, and my son and his wife and their children. I am an empty nester. My children are married and they have their own family. But so I am a mom. I am a daughter as well. My parents are still in my life. It's a great blessing. And I just want to tell you the best role that I love is this. I am a grandmother to 4 amazing grandbabies. And let me tell you, these kids have control over my heart. And this is the best role that I really enjoy, being a grandmother. A little bit of background information about me as an attorney. So I say I did things backwards. And what does backwards mean? I got married very early in my life, had children, finished my undergrad, and my husband is an attorney. He does personal injury, and for many years I was his office manager. And then I came to a time in my life when my daughter was about to start college, and I felt like I can't just be an office manager all my life. I wanted to do more. And at that time, I decided to go to law school and get my law degree. You know, it was an interesting time in my life. Me and my 2 children were all 3 of us were in college at the same time, and my poor husband, you know, in the evenings was quite bored sometimes. But he's amazing, and he really supported me in my life plans. After graduating from law school, it was natural for me to join my husband in his practice and do personal injury. Never really clicked with me. I did it and I did it well, and things were fine, but I never felt fulfilled. And in law school, I did intern for a semester with an estate planning attorney, and I loved it. But it was natural for me just to graduate and join the family business. And then something interesting, tragic, but it really had a big effect on my life, happened 5 years ago. And this is why I do what I do. This is my aunt. She is an amazing woman. She was a professor in Stanford. She was a professor in NYU, just a brilliant woman. And 5 years ago, she had a stroke. And I want to say, thank God that she had a good estate plan in place to name me as her agent, as her advocate. This is her after her stroke. She, her mind was well, but she was completely paralyzed. She could not eat. She was on a feeding tube, and she could not care for herself. She needed nursing home care. And I stepped in to take care of her. I was not physically take care of her, but I was her advocate. So after she had her stroke, she had to have multiple surgeries. And I remember I was waiting for the doctor to come out and speak to me about what happened. Well, first of all, in the hospital, as soon as I walked in, they asked for her medical power of attorney. They wanted the documents, the legal documents, so that they could give me information about her. Thank God I had all the documents. I gave it to them and everything was fine. But this doctor walked out of surgery and looked at me, and he's like, the first thing that came out of his mouth, he's like, so why did I do this surgery for this woman? I said, what do you mean? And he said, why are we doing anything for her? Just leave her to die. And it really upset me. And I said, that is not your decision to make. And we had an argument. And he said, you know, and if she needs another surgery, I'm not doing anything for her again. And I said, that's fine. There's other doctors that can really assist her. But at that moment, I realized how each person over the age of 18 needs to do an estate plan and needs to name an advocate for them, a spokesperson. After she became incapacitated, I had to hire aides for her, pay for her insurance. I became her. I took over everything that as if it was her taking care of herself. And I want to say, at that time, I didn't even have my own estate plan in place. I always felt like this happened to other people. It would never happen to my family. So this was a really big wake-up call for me. And then at that moment, I decided this is what I want to do. I'm very passionate about this. I'm very passionate about educating people as to create their own estate plan. And I opened up my own practice, and now I am doing this full time. So let's go into the estate plan portion. These are the documents that people believe that they need to have. And by the way, statistics tell us that 78% of adults do not have an estate plan, which is a very scary piece of information. So most people think that they need a will, they need a trust, healthcare directives, power of attorney. Yes, they do need these documents. But estate planning is not about the documents. The documents are a byproduct, okay? Please understand this, byproduct of very big and important decisions that they need to make, okay? Some people can, they go online, believe me, the probate court has so many cases of individuals who created a plan online and the plan completely failed. We're going to be going into this a little bit more. So what is estate planning about? Okay, some people think it's planning for death. It's really planning for life. It's planning for incapacity. What would happen to me if I am alive, but I can't make my own decisions, what does that look like? Who's going to step into my shoes? And it's also about keeping my family out of court and conflict. Okay. People don't realize that after they pass away, even though there's wonderful things, oh, my children love each other, we don't know what will happen when we pass away. And a good estate plan can avoid court and conflict. So why create an estate plan? Estate plan is an act of love. If we don't create an estate plan, we are leaving a mess for our families. Okay. When can this mess happen? Well, if I have a business, then having my family take care of that business. Okay. After I die, if I don't name agents, if I don't put a good plan in place, is leaving a big mess for my family. If I have minor children and I didn't name guardians for them, or there's actually long-term guardians and short-term guardians, I'm leaving a mess for my children. Second thing, it's about self-care. It's about naming someone to make those hard decisions for me. Picking someone. If I don't choose someone and to make decisions for me, guess what? A judge who has no idea who I am is going to make that decision for me. And just to give you a glimpse of, I hear about the good, the bad, and the very sad stories. I'm going to share a story with you about a son. His name is Craig, and his father, James. James called his son Craig, and he said, son, he started to get dementia. He wasn't feeling well to take care of himself. And James lived in Florida. He had a stepdaughter who was actually starting to call him, wanting to get his bank accounts. James felt uncomfortable. And so he called his son. Craig lived in a different state, and he said, I don't understand why she wants this information, what's going on. So Craig took some time off from work, came to Florida to deal with the situation. He wanted to make sure his father is okay. They went to an attorney. Okay, neither of them knew anything about estate planning. They just looked up an attorney and went to the attorney. And the attorney said, you know what, the best thing to do is have James declared incapacitated and give Craig guardianship over his father. They had no idea. They didn't know any better. And they're like, okay, that sounds like a good plan. Unfortunately, that was not a good plan. That was a horrible plan. The attorney got paid a lot of money. They went to court and they asked a judge to declare James incapacitated, and Craig would have guardianship over him. So what the judge does and what the court does is that they do an assets check on the person who's seeking to be a guardian. And unfortunately, Craig had some issues in his background. The judge ordered him to post bond. The bond company refused to give him, bond because he had some credit problems in his background. So therefore, the judge appointed a court-appointed guardian for James, which allowed that court-appointed guardian, number one, they get paid a lot of money. So all of a sudden, James's assets are being depleted by the court-appointed guardian. And now Craig has no control over his dad's assets. He cannot make any decisions for him. At first, James was in a really nice institution because he wasn't able to take care of himself, and he found a really nice place to stay at, a nursing home. The court-appointed guardian decided that that nursing home was too expensive, even though Craig's had enough assets to pay for it. The court-appointed guardian petitioned the court that he needs to take James out of that nice nursing home, put him in a subpar nursing home that was locked down. And he really did not have James's best interest in mind. He had his own best interest because he was reserving the money for himself to get paid. Okay. And unfortunately, this happens a lot. Unfortunately. Long story short, Craig was never able to, he went to the court, he tried to get access to be his dad's guardian. He was never able to do that. Eventually, James became very depressed and passed away. It's a really, really sad story, but it happens more often than you think. So the last thing about estate planning is control. Having control over that, it took a while for us to earn the assets or to obtain the assets that we have. And we have a right to have control over, to say who gets what and when. And we're going to talk about the when part a little bit later on. Okay. And so putting an estate planning in place gives us that total assurance that even if we are in a state of incapacity, or we get dementia, or we get old, or we get into a car accident, we have a good plan moving forward. Okay. So common misconceptions about estate planning. A lot of people think that you only need an estate plan if you are rich. This is absolutely wrong. Everyone who is over 18 needs an estate plan to be put in place. And we talked about some of the reasons why: incapacity and having control over your assets as well. Some people think that my spouse gets everything anyway, so why do I need an estate plan? That is absolutely false. If I have any assets in my name alone, once I pass away or I become incapacitated, that account is shut down immediately. My spouse does not have access to any account in my name only. Okay, so Florida is a separate state, so that each spouse can have their own assets. We also have our own businesses, and businesses have their own bank accounts as well. So this is completely false. Last thing is that I don't have enough money to pay an attorney. So I do want to tell you the cost of not having an estate plan in place. And this was a study made by Goldman Sachs this year, the high price of death. And they said that they went throughout the country to survey a lot of people. And they found that it takes about 13 months, okay, to handle an affair for someone who passed away. 20 months if it goes through probate. Probate is the court system. At least 4 family members were involved in the process. And these family members had problems in job performance. 52% said that dealing with the loss negatively affected their performance at work. The cost was about $12,700. That's almost $13,000. Okay, doesn't matter if you cannot. A lot of people think I can't afford an attorney now. Well, guess what? After your passing, there's a lot of cost. It costs even more. It also costs them their health. 57% experienced clinical, physical, or psychological symptoms of stress. Okay. So I want to give you a glimpse, and I'm going to try not to use legal jargon to explain to you what the court process is. So going to court is very different than what we see on TV. Okay, it's not glamorous. If you talk to any attorney in any practice area, they will tell you that we need to avoid court as much as possible. Because once a case is within the court system, we have no control over the outcome. Unfortunately, absolutely no control. So probate is the court process when someone passes away without a will or with a will. Can probate be avoided? Yes, it can, and we'll talk about that later. So again, as soon as someone passes away, all accounts are frozen. Imagine that I pass away and then my accounts are frozen. My family cannot access my money to pay funeral costs. How about my insurance, my home insurance, if I own a home, or my mortgage? How does that continue until a judge actually qualifies my will in court? So maybe my family members have money that they have to pay out from their own accounts to keep things going for me. Maybe they don't. So this could be a really big problem for my family. Another thing is, once a judge okays a will, there's a whole lot of things that need to be done as well. There could be assets in another state, and if it's a probate process, a probate account has to be opened up in the other state as well, if there are assets in another state. So it can really get complicated. Attorney fees are determined by a statute, by Florida law. It actually tells attorneys how much they can charge for their fees. And it costs about 2.5% for court fees from the account, from the estate. And you can imagine that can get very, very costly. So also, if I don't have a will, our children inherit the money outright when they turn 18. Now, in my book, an 18-year-old is not an adult by any means. A friend of mine was telling me a story that her husband, when he was in his first semester of college, inherited money outright. He inherited $100,000. $100,000 now, for an adult, it's a good amount of money, but it's not huge. So what he did, he left college after his first semester, and that $100,000 was completely depleted within 2 years. He discovered after 2 years he had no money. He had to go back to school and wasted 2 years of his life. So inheriting money at 18 can actually be detrimental to our children. And you can think 18, even if you don't have that money, and that money can be in the form of life insurance as well. So keep that in mind as well. Okay. Also, estate planning is about being very organized. At this time, in the Florida Department of Unclaimed Property, there's $2 billion of other people's money with the Florida state. How did that money get there? It gets there when someone has assets and their family have no idea that he has a bank account with Wells Fargo, or he has a brokerage account with a brokerage company. After a year or so, if you have a bank account and there's no activity on it, the bank will try to find you. They're going to send a letter to the last known address, which may not be your address anymore. You passed away, the property was sold, so other people are getting your mail. They find that mail and they throw it in the garbage. Guess where the bank was going to deposit the money? It's going to give the money to the state. And there's $2 billion of people who have passed away, okay, with the Florida state. So creating an estate plan also organizes you so that your assets do not get lost in the State Department of Unclaimed Property. So how do you avoid probate altogether? By creating a living trust, a fully funded living trust. If you can imagine, this trust is your treasure box. Your treasure box includes your assets, your retirement account, your bank accounts, your property, your bonds, your life insurance. It's your treasure box that includes all your assets. Inside of it, you are the beneficiary of those assets. You are in control of those assets. But if you become incapacitated, someone can immediately step in and take care of those assets for you. Or if you pass away, someone can immediately step in. Your accounts do not get locked. Also, you completely avoid the court system. and administration of your assets happen inside inside the attorney's office. It's a very private matter. So when you go through the probate system, the court system, everything that happens in court is public records. Anybody can access your public records. But when you create a trust, it's extremely private matter, and it happens in an attorney's office. All right, so I want to take a few minutes just to give you an idea about the conventional way of doing the estate plan and how I do things differently with my clients. With the normal way of estate planning, it's just creating documents. These documents may serve your family and they may not. It's just attorneys, they have these forms on their computer and they plug in information. It's a one and done, so that once you do it, that's signing these documents is the end of your relationship with that attorney. Assets are missed and end up with the government. Money goes through the probate and the court system, and it's a very public matter. And whereas doing a trust would make this completely private. Assets being inherited, they may go to people that you may not even know. And I'll give you an example, a situation where a grandfather gave his granddaughter, he said, when I die, I'm going to give my granddaughter this house. So he gave her his house. The granddaughter was married at the time. She did not have any children. But a few years after, she passed away. Guess who took her house? Her husband took that house. He remarried, and that house was completely taken by people that the family did not even know. The family did ask that her husband if they can have the house back, that the grandfather really intended for this house is just to remain in the family. And guess what he said? He says no. And the law was on his side. Okay. Another thing is that your minor children may end up in foster care if you don't name temporary, if you become temporarily incapacitated, and if you don't name temporary guardians for your children. Okay. So how the plan can work for you when you need it. Number one, we make sure that your family, you have money is available quickly and privately for your family. That means that your accounts do not get shut down if you become incapacitated, and your family does not need to go through the court system to be able to support you. Making sure that individuals that can hurt you cannot access your accounts or raise your children. Okay. Now, we know our family members, and we all have these family members who look amazing on paper, but we know that they're not the best people to raise our children. They're not the best people to make decisions for us. But when we leave this up to a judge who has no idea who we are, we have no control of that judge's decision. Unfortunately, I want to say unfortunately, a judge is a human being. And how a judge makes a decision, as human beings, a lot of us, he may have certain biases that we don't know. He may make his judgment based on certain things different than us. So making sure that our needs are protected, we need to make these decisions for ourselves and not allow a judge to make these decisions for us. Okay. With the right plan in place, no assets will be missed and end up with the government. And by naming short-term guardians as well as long-term guardians, our kids will not end up in foster care. Also, the relationship with our clients, signing the documents is just the beginning of the relationship. It's a lifetime relationship. We make sure that the plan is still working for you. So anytime there's a life change in our life, we need to update our estate plan. And for my clients, I have a review meeting with them every 3 years to make sure that that plan is still working for them. So because you're here today, the first step that you need to do is not just a consultation. It's a family wealth planning session. What this session is to deep dive into your family dynamics, into your assets, to give you clarity as to the decisions that you need to make, okay? I operate on a flat fee, so there's no surprises, there's no extra or any hidden fees. This is a plan that I charge for $700. It's a 2-hour plan, and it's a 2-hour meeting with me to do a deep dive into everything, a lot of questions. I ask a lot of questions because sometimes you don't know what you don't know, okay? And so that you can make an educated, a lot of empowered and educated choices. But there is, because you're here today, there is a way to get this plan, okay, for free. And it's my gift to you. It's a $750 value. But in order to secure this plan, you need to do 2 things for me. Number one, to fill out an intake sheet for me, because that gives me enough information about you so that when we meet together, we hit the ground running and we do a deep dive into your specific situation so that you can have clarity and get empowered to make the right decisions for you and your family, okay? And the way to get this for free is by filling out that intake sheet for me. And number 2, you secure the 2-hour meeting with me with a credit card. That credit card never gets, I don't run your credit card. You can change the time, you can cancel, and you can change the time of your meeting. The only time that I will run that card is if you just do not show up and you don't call me, okay? Or you don't want to fill out that intake sheet, and that's fine. I have clients who say, you know what, I don't want to fill that out, which makes the meeting close to 3 hours because I have to get that information from you. And I am okay with that, but I will charge for it if you don't fill out that intake sheet for me. My other bonus and gift to you is $250 off of whatever package that you choose, because I have different packages, if you schedule this meeting with me today. And this is the next step to schedule a family wealth planning session with me. This is a QRL. If you can use your phone to schedule, it will take you to my calendar to schedule the meeting with me. And you will get that $250 off of whatever plan that you choose. This is my contact information as well. If you'd like to take a picture of that and keep it with you. And my assistant here, Jen, can you please put in the chat also a link to my calendar? I'm gonna.
Yes,
I still wanna.
I've already added it in the chat and also the link to the online intake sheet.
Okay. Perfect. Thank you. Any questions? Do you have any questions?
We have a question here in the chat box. The question is, if I have a living trust, do I still need a will?
If yes, if you have, okay, that's a great question. Okay, if you have a living trust, if you have a trust, you still need a will. Yes, you do. So what I do is that I create something called a pour over will. And what that pour over will says, that if I miss something, so if I missed something in my trust, my intention is for me to, so that all my assets go through the will, okay? And so it's like a catch-all. If I forget to put, if something's forgotten outside the trust, this will allow my personal representative to actually scoop up everything that was left out of my trust and make it part of my trust.
Okay. Another question is, what's the difference between a living will and a will?
Okay. Yes, that's a great question as well. Okay. So a living will is completely different than a will. A living will is for incapacity planning. And this is where I say, if I am in a vegetative state, I don't want resuscitation, or I want resuscitation. Some people can get very, very specific as to what they want, who they want to make decisions for them. It's end of life decisions. It's called a living will. The will, on the other hand, is what goes through the probate court to say who gets what after I pass away.
Okay. Another question is creating a trust a sure way of avoiding going to court?
Okay, interesting question. Yes and no. Okay. A trust is a sure way of not going through the court system if it's fully funded, if the trust is funded. And what does that mean? Is after you create a trust, you have to retitle your assets in the name of the trust. If there are assets that are left outside the trust, then they're going to go through the probate court. Okay, these are two ways. Another thing also is if somebody contests, anybody, by the way, can contest a will or a trust and say that they're not valid. If somebody brings up this files in the court that they feel like, you know, there's the will or the trust is invalid, then yes, it will go through the court system. Okay, our time is up. I want to thank you all for attending the webinar today. I hope it was very beneficial to you. And I wish you a blessed rest of your day. Take care, everybody. Bye-bye.